I'm Melissa Mancini with Canadian HR Reporter TV. I recently sat down with Krista Siedlack, a lawyer with Bernardi Human Resource Law, to talk about the basics of severance packages. What's the difference between the Employment Standards Act and common law?
That's an excellent question, and I think that oftentimes employers think that the ESA is the only thing they need to consider, and the common law is just as real as the ESA. The common law, in essence, is judge-based law, whereas the Employment Standards Act comes from legislation. So there are two entitlements that an employee is entitled to on termination. The Employment Standards Act sets out the minimums, so it's their minimum entitlements to notice and severance. The common law is the bump up, the additional amount of notice that they're entitled to. So what's happened is many judges have said that what's in the Employment Standards Act isn't enough time for an employee to find another job. So they bump it up and they look at a variety of factors that are called the Bardell factors. It's a case that came down that said the factors that judges should consider. And it considers stuff like a person's age, length of service, position in the organization, and how the availability of alternate employment in the workplace. And that bumps up the notice period. But what's important to appreciate is that an employee is entitled to both.
What's a win-win severance package?
I think a win-win severance package is one that appreciates the employee's the psychology at play in terminations, and that appreciates that a termination is a very hard thing for an employee to swallow. You're taking away something that's very important to them. You're taking away their job. So you need to give a package that's respectful but not overly generous. So what I typically recommend to my employer clients is that they give them a fair package and leave a little room to negotiate if the employee comes back. So that way they can sweeten the pot a bit. So how that's winning for the employer: A, the employee might take the original package and go away owing a little bit less, or B, they leave themselves that room to negotiate to sweeten the pot a bit.
What should be included in the package?
The package needs, what the courts have said is that an employee is entitled to be made whole during the notice period. So whole means they're entitled to everything they would have received the day before they were terminated throughout the notice period. So it should consider stuff like their base salary, vacation pay, benefits. You should consider whether or not they were part of a bonus plan. That type of stuff should all be considered in the package.
When should a company stand firm on a deal?
With an employee who has reasonable demands. So they want the letter tweaked in a little bit, they want a little bit more notice period, but they're being reasonable, and you know you've left yourself some room to negotiate, then I really would try to settle it before it goes any further. If what they're asking for is so out of the ballpark of what you know to be a reasonable package, then I don't think there's any point in negotiating. If you're offering them a month more, they're not going to take it because they want 8 months more. So you're not going to bridge the gap. You're better off to keep the money and wait until they get to the next step and then offer it then. The miraculous thing about terminations is that over the passage of time, most employees get less upset and they're willing to take less money. So if you have to get to a mediation in order to settle it then, that might be the next avenue you need to take.
How should HR establish an employee's failure to mitigate?
I had a case a number of years ago, which is probably the best example, where a teacher was terminated in June, and she was, as all employees should, look for work when she's off. And she showed up at mediation. She started a litigation for a better package, and she showed up at the mediation and she had only looked for 4 or 5 jobs throughout that period of time, and it had been 6 months, so I don't think that's really reasonable. But what my client had done is my client had kept clippings in the newspaper or on the website when she saw jobs that were in a 10-kilometer radius of where the employee worked. So at mediation we presented these to the employee and we asked her to explain why she didn't apply to any of those comparable jobs. And in the end, it mitigated against how much the employer had to pay because she wasn't able to prove she took reasonable steps. So what I would say to HR is, I know it's time-consuming to do, but if you can check Workopolis once a week and just see if there's any similar jobs that she could have applied for, print it out, stick it in the file. If you have, if you're part of HR and you have a network that has jobs, print it off, put it in the file. It just helps you in the end prove that they didn't take proper steps to mitigate.